That would be just a great shot.
I want to go ahead and call a Public Works Committee meeting to order. I didn't take the quorum. Can I get everybody's attention, please? I'm going to go ahead and do a consent agenda to take pretty much nearly everything off the agenda except for about 3 items. Unless there's objection, it'll be ordinance 1258, 59, 60, 61, 62, 63, 64, 65, and 66. All of these are easement bills, alley abandonments.
Mr. Chairman, I'd like to move approval of the consent agenda.
Second. All right, let me read them hopefully quickly. Ordinance 1258 by Councilor Roberts, an ordinance authorizing the acquisition of certain right-of-way easements, drainage easements, temporary construction easements, and property rights by negotiation or condemnation for use in public projects of the metropolitan government, initially for purposes of Public Works Department project number 2016 R039 James Avenue sidewalk improvements. Ordinance 1259 by Council Lady Allen, an ordinance authorizing the acquisition of certain right-of-way easements, drainage easements, temporary construction easements, and property rights by negotiation or condemnation for use in public projects of the metropolitan government, initially for purposes of Public Works Department project 2017 R018 25th Avenue South sidewalk improvements. Ordinance 1260 by Councilman Anthony Davis, an ordinance authorizing the acquisition of certain right-of-way easements, drainage easements, temporary construction easements, and property rights by negotiation or condemnation for use in public projects of the metropolitan government, initially for purposes of Public Works Department project 2017 R016 Stratford Avenue sidewalk improvements. Ordinance 1261 by myself, an ordinance authorizing the acquisition of certain right-of-way easements, drainage easements, temporary construction easements, and property rights by negotiation or condemnation for use in public projects of the metropolitan government, initially for purposes of Public Works Department project 2017 R21 Walford Drive sidewalk improvements. Ordinance 1262 by Council Lady Vercher, an ordinance authorizing the acquisition of certain right-of-way easements, drainage easements, temporary construction easements, and property rights by negotiation or condemnation for use in public projects of the metropolitan government, initially for purposes of Public Works Department project number 2016 R43 Hobson Pike sidewalk improvements. Ordinance 1263 by Councilman O'Connell, an ordinance authorizing the metropolitan government of Nashville, Davidson County to abandon existing combined sewer main and easements and to accept new combined sewer main, combined sewer manholes, and easements from property located at 10, 11th Avenue South. Ordinance 1264 by Councilman Kendall, an ordinance authorizing Pacific 35th and PR LLC to install, construct, and maintain aerial and underground encroachments in the right-of-way located at 350 2nd Avenue North. Ordinance 1265 by Councilman O'Connell, an ordinance to amend the GIS street and alley centerline layer for the metropolitan government of Nashville, Davidson County by abandoning a portion of Ewing Avenue and Alley 197 right-of-way. Ordinance 1266 by Councilman Bednane, an ordinance to amend the GIS street and alley centerline layer for the metropolitan government of Nashville, Davidson County by abandoning a portion of alley number 1623 right-of-way. Now that I've read through the consent agenda, is there any objection? All right, all those in favor? Aye. And any opposed? And we recommend approval on all of those. So that brings us back to ordinance 1202 by myself and others, amends the Metropolitan Code of Laws to regulate dockless bicycle and scooter operators and to establish a permitting system. So the posture that we are in now, we've already adopted the first substitute before y'all is the second substitute that makes improvements on the first one. We also have several amendments. Also procedurally, it's my hope that we adopt the second substitute tonight, and then we will have to defer second reading because traffic and parking did not take it up for some reason, or it wasn't on their agenda even on their last meeting. And they will be holding after we take action tonight, hopefully to adopt it, the second substitute, that they will schedule a special called meeting just on this ordinance on July 30th. So that's the posture that we are in now.
Mr. Chairman, Mr. Jamison, how many times have we deferred this? Are we okay? Just
I think that'll be the last one, won't it?
We've got Mayor on second, right?
Yeah, we've done it 2. This next one will be, if we do it tonight, it'll be 3.
So it'll be 3 tonight?
Isn't that
For
right?
two.
I thought this was, then he'll submit a notice to the clerk to reinstate it on the agenda, so.
I'm just making sure you, okay, so you'll have to submit a notice to get it back up there. Okay, that's fine.
All right, so I will move the substitute, which, and I realized it this afternoon, if you want to read it, the long summary that I sent to y'all 2 weeks ago. And basically, this puts in place a permitting process through the Transportation Licensing Commission of dockless or even dock to shared urban mobility devices. I'll call them scooters and bikes because it's a more common term. It sets it up through under Billy. Billy will be in charge of it in his commission, and it's something new that's in Nashville. Obviously, Bird came to Nashville and operated for several weeks, but there are other companies that are wanting to come to Nashville. Lime is the most prominent one that I know about, and I'm sure many of y'all have been contacted about. It sets up a very, I think strenuous regulatory structure in the sense of the TLC will be in total control of the project as far as regulating the operators, making sure that they stay in compliance. There are caps that are in place in the ordinance, and I can go through those if you would like. There's a per fee per scooter or bike that is paid to Metro, which is to help recover the cost of the administration of the program. There is a $25 fine for anyone that rides on a sidewalk or improperly parks a scooter or bike, and it's kind of the first of its kind, and we're still figuring out how to do it. But the idea is basically to ticket the scooter. That way, whether it's Bird or Lime or somebody else, that company pays that fine to Metro. Then it's up to the scooter or bike company to recover that from the user. We've reaffirmed the prohibition on riding scooters or bikes on sidewalks, and even strengthened it with a $25 fine. There's a lot of things, and there's a section in the bill to encourage companies that do these that will be offering these kinds of vehicles for rental to offer them in low-income areas for low-income riders to have potentially cash-based options or low-cost options for them to be able to have access to it, because we have a lot of things. Was it transportainment? Is that the term? What is the term? Transportainment. Pedal taverns, golf carts, pedal carriages, pedicabs, horse carriages that are pretty much only utilized by people that are visiting here in Nashville. I think these devices, while of course they're going to be used by people that visit here, but I think it could, for some, I don't know how many, but I think at least for a small segment of Nashville could be really impactful in how they get around the city and be a cheap, inexpensive, accessible way for them to get around the city to and from transit, and at least from some of the emails that I've seen, life-changing for a few folks. So I want to move the substitute. I don't have any plans on moving any of my amendments. I do have a question for Mr. Jameson. For the amendments, obviously you know what they are because you wrote all of them. But we have the issue between the first substitute and the second that there's a substantive enough change between the first and second that necessitates the prior notice isn't sufficient, that they have to we have to resubmit it. If we were to take up amendments, say at our first August meeting, would that be enough of a change to necessitate another referral, or do we need to take all of them up tonight?
A couple of points. The committee does not need to approve separate amendments for them to be considered on the floor. So it's within your discretion to take them all up now or not. The charter requires any ordinance that affects traffic and parking issues to go before the Traffic and Parking Commission. The analogy we have discussed, but to share with others, is if there is a substantial change between what the Traffic and Parking Commission considers and what the council eventually considers by substitute, it's sent back to Traffic and Parking. The analogy is if you've approved something that the Planning Commission sent here, and then you introduce a substitute that substantially changes the underlying zoning bill, historically we send that back to the Planning Commission. There is no set criteria on when a substitute is a substantial change. We just work with staff for planning and try our best to determine, could this be viewed differently by the Planning Commission members? The same rationale applies to the Traffic and Parking Commission. There are no set criteria. I would submit that the second substitute is substantially different from the first and should go to the Traffic and Parking Commission. If subsequent amendments alter it so drastically, the same rationale applies, but if the second substitute is introduced and those changes are carried forward, I assume most of the amendments are going to be more technical and not result in that change.
So we don't necessarily have to do the amendments tonight that they wouldn't trigger an automatic, that they would have to be re-referred to traffic and parking.
That's my best guess.
Here, is that
I agree with Mike.
good? Right. So,
In which case, I do not feel obliged to run my.
okay. And I've got 3, I think, amendments, and I'm not going to run them either tonight. But although there are, I think, some merits in them, particularly with, and I'll get to that on later, but does anybody have any questions for Mike or Terry or anyone else on it? Yes, ma'am.
Just insurance, because the way Bird was introduced to Nashville has a very dramatic way. So I just want to make sure, in case those happening occurred, is Metro indemnified, or if anything happened, Metro will be still liable if that operator or customer were to somehow put Metro as a party of their lawsuit.
As currently drafted, the second substitute makes clear that the liability onus is on the operators, the owners, and not upon the metropolitan government. And that is applied in similar situations, and that would be probably upheld by any court here in terms of our deference, our deflection of liability.
Just to follow up on the council lady's question, in the ordinance was a indemnification policy that was required by the company. That they had to demonstrate that they were carried by an insurer.
Yes.
Why that number? And it seemed to me that is possibly too small a number.
I don't know why that.
Who came up with that number for the right amount of insurance?
Are you talking about the $1 million? I assume we consulted BC Cobb about that.
I mean,
I think we did. He's the Metropolitan Director of Insurance.
okay, because most buildings have much larger indemnity policies than that, and you're dealing with a building, slip and fall in a building, much less something moving in our right-of-way.
I believe in a number of places, I'm looking at John too, in case he wants to correct me, but I believe in a number of places in the Metropolitan Code, we do use $1 million of general liability insurance.
I think that was probably taken from some of the other
Maybe
regulatory.
from some of the TLC provisions as well require $1 million.
Well, I do wonder that it's a little bit of an Austin Powers moment, $1 million. Just as not what it used to be, particularly a head injury, is the payout on that is going to be a lot bigger. The next question is helmets.
We have to get the traffic approval before second reading.
Do we require them? Can only the state require them? They're not required?
Amended under the draft. They're not required under the draft.
Okay, because I know the feds have struggled with motorcycles and helmets over years and have found dramatically lower health expenses. And so you have an uninsured person in a bike not wearing a helmet taken to a metro hospital, particularly our own, you're talking about a very expensive situation, which is what happened with motorcycles in the federal government. Can we require helmets? We could put that in the ordinance to require helmets.
The state law currently doesn't require them for anyone over 16. But in speaking with a lot of the biking advocates, the helmet requirement, particularly for someone that's visiting here or maybe going to work or something like that, would be a discouragement to riding. So it's a balance there between safety or people actually riding them. So that's the dilemma.
Okay. On it. Okay, but the $1 million policy is not per case, right? It's cumulative.
It's
Single incident, I think.
yeah, let me see. permitted operators shall have a minimum of $1 million in automobile insurance. I'm sorry, it's $2 million in commercial general liability insurance. My mistake.
But commercial liability insurance, that's not the casualty that, I mean, it's going to be hard for anybody to do $2 million worth of damage on your bike, but you could sure do that amount of damage to yourself, or you had a bad day, 3 of your riders ended up that way.
I mean, they additionally are required to sign and record an indemnification agreement in a form approved by Metro Legal, which agrees to indemnify and hold harmless the metropolitan government. And we also ask them to require their users to release and waive all liability as to Metro.
Okay, but if you're, again, and we can move on to other things, if you're hurt riding this, you're taken to one of our hospitals, and we will be covering you. And then if they sue, they're suing the carrier. That's capped up to $2 million for the year. Everybody's suits.
I've seen it.
And then
All of the other ordinances are single instance, and this one is not specific. We may have to.
To the extent there is any ambiguity there, that would certainly be something that the MTLC could rule make about and adopt like more specific requirements.
So change the number depending on the average number of monthly riders, maybe. So that if you had a big volume operation, they weren't getting away with just a $2 million policy.
But I think we would want it to look like the other ones that the MTLC regulates.
Okay.
There's extensive authority for the TLC, not just on this, but on any number of things to affect any kind of, like put in place any kind of rules, and it's on, I mean, literally on just about anything. I mean, we set some hard caps or fees in place, but I mean, the TLC has broad authority to set a lot of, because it's a pilot project, you know, as we go along, they may need to change things, and it may not, that way it doesn't have to come to council for an ordinance, they can just do it, you know, as they meet monthly. Or, you know, Billy.
Or special meetings.
Or special meetings, yes.
Okay. Thank you, Mr. Chairman.
Do we have any other discussion on the second substitute? All right, all those in favor of the second substitute say aye. Aye. All those opposed? All right, the second substitute is adopted. So I guess I will then make a motion to defer second reading one meeting. Is that right, Mike? Correct. And so that will then bring it back to Public Works and the other committees. Is that right? Okay. So I will make that motion a one meeting deferral.
Second.
All right, any discussion? All those in favor?
Aye.
All right, one meeting deferral. And now we are to ordinance 1203 by Councilman Rosenberg, amends the Metro Code relating to scooters, inline skates, and roller skates by defining scooter and removing certain requirements. Councilman Rosenberg.
Defer 2 meetings, please.
2 meetings.
Switching things up.
All right. Any discussion on a 2 meeting deferral? All those in favor?
Aye.
And we recommend a 2 meeting deferral. Then we just have one last item. It's substitute ordinance 1197 by Councilman Cooper, approves the plans for a solid waste processing facility to be located at 4648 Ashland City Highway, Nashville. Councilman Cooper.
Well, I think the bill has a new lead sponsor. I'm looking at Mike Jameson here and Jonathan.
We signed underneath your name?
Oh, actually signed underneath my name. But I think his intention is to withdraw the bill later tonight as the elected representative from District 1.
Is there any discussion on, I guess, recommendation of withdrawal? Or does the committee want to make that recommendation, or?
Well, don't you wait for the councilman to make it at the meeting?
So we can take no action on it. Would that be appropriate?
That's fine.
Okay.
I do think it's unclear that the acting vice mayor may have a public comment at the beginning of the meeting. I don't know if that was concluded or not. Were various people who wanted to say something in a public meeting, perhaps tonight, wanted to come and talk about it.
She'll have that. I don't think anybody's signed up to speak on this that I know of.
Okay. all right? Because that had been discussed at one point. But you've talked to Jonathan more recently than I have, but that is his intention, I think.
Councilman Schulman.
Thank you, Mr. Chairman. I think what Councilman Cooper was talking about was that at the last meeting, there was a public hearing on this.
Right, he was contemplating a 2/3 approved, council member supported public hearing on this bill. I think he has since decided to simply withdraw it.
Okay, because what I thought people were invited back tonight to speak. There was discussion, as I remember, about another public hearing tonight.
Well, I do, and when I was not here, Council Lady Weiner, I think, was at the public meeting. I think there is some public discussion.
It was, yes, discussion.
Motion.
Yes, motion.
Mr. Chair, if people are here to speak, even though he's withdrawing, would they be given that? Would they be afforded that opportunity because they weren't given that opportunity at the last
I
meeting?
think it would still, the sponsor or someone would need to make a motion to have the public.
Rule 32, he makes a motion to allow public comment on a bill, takes 2/3 approval, and there you go.
So you or anyone else can make that
I
motion.
don't think we have an authority on this here.
Yes, ma'am.
He will be withdrawing the bill. He will not move to withdraw the bill. He does not wish to have the public hearing, nor does the community, given the fact that he's going to withdraw the bill.
Okay.
But we were asking if somebody was here from the community because they had intentions to want to speak on it, would they be afforded that opportunity? I'm going to talk to him about it because if somebody shows up, I think they should be afforded that opportunity. And so it'll be his choice because he's a council person. But that was the concern of the community, that they did want to have an opportunity to speak on the bill since it came before the council.
All right.
Just a quick comment. I think Councilor Johnson's right. What I'm trying to remember is what happened. There was some confusion at that time. And what I thought happened was that I wasn't sure whether people were invited specifically back tonight just in case they wanted to speak. So
They
there may be
were
people in the
upset
audience.
because they were not afforded the opportunity to have a public hearing.
Okay. So we may want to clear that up with the councilman to figure out what he wants to do.
And I'm speaking to that issue because that's where my mother's home is.
Okay.
My
I just
stepfather's.
thought there might be people coming back tonight who thought we might open it back up again.
That's why I said that's why I asked the question. If people did come back with that understanding, could they be afforded the opportunity to do that?
Again, he can make the motion, Rule 32. There was discussion of it at the last meeting, but the way the rule is envisioned is you make the motion at the meeting where you want the comment to be made.
Okay.
Madam Vice Mayor.
I am happy to go get him. He's right down the hall. When I was at the meeting the other night with the community, I shared with them the specifics of the rule, and that if that's what the council member wished to do, is to open the public hearing, we had that option. We could do that. He has subsequently visited with his folks, but I don't want to speak for him. I'm happy to duck out and go get him.
I think that can be figured out offline because we're not going to take an action on the bill. So, is there any further business?
Did you do 1267?
That's what this is. That's what this one is.
No, this is 1197.
No, I did not. It's not on the agenda.
It's on page 10 of the regular agenda. Councilman Syracuse's bill.
It's not on the Public Works agenda.
Yes.
Committee agenda.
Rosie must have overlooked it. Which one is he on the agenda?
1157?
The ordinance to amend the geographic information system, street.
I don't know if we can do it. I guess we'll go ahead and, you mind if I read it?
I have 2 other committees.
Ordinance 1267 by Councilman Syracuse, an ordinance to amend the GIS street and alley centerline layer for the Metropolitan Government of Nashville and Davidson County by amending a portion of Blue Hills Drive right-of-way.
So moved.
Second.
Any discussion? All those in favor?
Aye.
And we recommend approval. I don't know if we can do that, but we just did. All right, any further business? We stand adjourned.
That's my agenda.
Yeah.